In 2021, Officer Blasingame and another Capitol Police officer filed a civil lawsuit against Donald Trump. They argued that they should be awarded financial damages from the former president for the pain and trauma that they endured on January 6th. President Trump tried to get the case dismissed, claiming that because he was the president at that time, he was immune from civil cases related to January 6th. But today, the United States Court of Appeals for the District of Columbia Circuit rejected that assertion. As the three-judge panel put it, when a first-term president opts to seek a second term, his campaign to win re-election is not an official presidential act. In other words, the panel decided that Trump's actions on January 6th, as alleged in these lawsuits, were not part of his duties as president. So the lawsuits cannot be thrown out at this stage. And that is a huge deal. In addition to Officer Blasingame's lawsuit, 11 other Capitol Police officers have filed suits against Donald Trump, and members of Congress have also filed their own cases. Now, Trump could still try to make the case in court that based on the evidence, he should be held immune. But now, at least, these plaintiffs will get their day in court, and this ruling will make it less likely for any future immunity claims that Trump makes to succeed. We've just learned that Judge Tanya Chutkan, who is the judge in the special counsel Jack Smith's federal criminal election interference case, has denied Donald Trump's motion to dismiss that case on grounds of presidential immunity. Now, Trump is surely going to appeal that decision, but it doesn't look good for the former president. In civil court and in criminal court, Trump and his legal team are trying every route that they can to claim that he is immune from any legal liability. The question, though, is where do these arguments work and where do they fail? Joining me now is Lisa Rubin, MSNBC legal analyst, and Jen Taub, Western New England University law professor. Thank you both for being with us tonight. First question for you, Lisa. Tonight, we have two decisions dealing with presidential immunity. The U.S. Court of Appeals for the District of Columbia Circuit concluded that Donald Trump's actions on January 6th were the acts of a candidate, not the official acts of a president. And for that reason, he is not immune from civil suit. Meanwhile, Judge Tanya Chutkan has denied Trump's motion to dismiss the criminal federal election interference case, concluding that presidential immunity provides no defense for Donald Trump. What do these two rulings mean, and how will they implicate the other cases that Donald Trump faces?
Well, Melissa, these two rulings are really different in a way, not only because one is from an appellate court and one is from a district court, but one arises in the civil context where there already is Supreme Court precedent and the other does not. So let's take the Chutkan case first, because it is considering federal law and federal constitutional defenses, and she's very clear to say that her decision deals only with the case before her, and she's not necessarily saying that he's not entitled to immunity, for example, in a state prosecution. But what she is saying is the text, the structure, the history of the Constitution affords a president no absolute immunity for acts that he takes while he is president, period, full stop. The appellate court's decision is really different because in Nixon versus Fitzgerald, the Supreme Court already decided that a president is entitled to absolute immunity for his official acts in a civil case for damages. And so based on that, the question for the Court of Appeals was really, was Donald Trump acting in an official capacity with respect to the allegations brought by the members of Congress and the police officers who sued him civilly for their injuries? And they decided that at this stage, taking the allegations made by those plaintiffs as true, as they must on a motion to dismiss, they can't grant him immunity, but he is free to raise his claim of presidential immunity again after discovery, after he collects evidence. Does it look good for him? No. But is he foreclosed from doing so? Also no.
Excellent. So that's probably going to be raised again in the course of a trial if one should happen there. But back to this ruling from Judge Tanya Chutkan. So, Jen, this decision is surely going to be appealed to the D.C. Circuit and will probably be appealed even further on to the Supreme Court. Given the composition of the court, given the nature of the D.C. Circuit, what is the likely future for Judge Chutkan's decision? Is this going to stand on an appellate review at the Intermediate Appellate Court and at the Supreme Court?
That's a great question. And just piggybacking on what Lisa said, the same court that decided the Blassingame case today is the court that will hear the appeal from Judge Chutkan. Now, it's not definite that she'll get the same, 3-judge panel, but it's most likely that her decision will be affirmed and that it will go up on appeal to the U.S. Supreme Court. The reason why I believe it will be affirmed is for the reason Lisa mentioned, which is the case that the precedent for allowing a president to face civil trial is kind of a higher standard, in that the thinking was at the time, if we're going back to Nixon versus Fitzgerald, or we're going back to the Clinton and Jones case, the idea is that you don't want at least a sitting president distracted from their duties while they're in office. And so there would be official act immunity here in that civil case that we just talked about. The question is a factual one as to whether Donald Trump was campaigning when this insurrection occurred, when his actions led to that, or if he was acting as president. We all know that that he was campaigning. In this case, with the criminal case, the case is being brought now. He's not a sitting president, so we don't have the OLC memo, and we have this. We have a situation where a very strong argument is made here by Judge Chutkan that both his constitutional claims as well as his claim here for immunity just can't stand. We don't have a monarchy. We don't have the divine right of kings, is what she said. His power does not come from God. It comes from the people, and he's not even president right now.
Well, with that in mind, this is not the only legal case that Donald Trump is facing. Let's pivot to Fulton County, Georgia, where Judge Scott McAfee did not set a trial date today. But did you, Lisa, get a sense of how he felt about the Trump team's scheduling preferences, which could put this trial out to the end of the decade?
I didn't, Melissa, and that was actually what surprised me. I think he was trying to see whether there was any room to schedule a trial, a place where the prosecution and the defense might agree. But as you previewed, Steve Sato really gave him no opening. He essentially said, August is way too soon, and any time after November is too late, and in between, my guy is busy campaigning. And so there was no place. Steve Sato was very agreeable, I should say, and much less contentious, for example, than the lawyers I've been watching in the Trump civil fraud trial here in New York. But despite his very polite approach to the bench, he wasn't allowing really for any opportunity to try his client at all. He laid forth the trial schedule and said, he's going to trial in D.C. in March, and then he's got a trial scheduled in Florida in May, and then thereafter he's supposed to be tried in New York. I'll pause there and say that's not accurate. Actually, there is the hush money case in New York still scheduled for March. But the bottom line is Steve Sato wasn't allowing for the possibility that his client can be tried in the next year. And Judge Scott McAfee sort of withheld comment and said, okay, we'll set a trial date at a later time, and didn't really give anyone there a sense of what he's thinking, other than by being deliberate and pausing and not necessarily engaging with it right now. Maybe he's trying to postpone some of the more contentious aspects of the proceeding before him.
Well, Jen, do you think that we are ever going to get a sense of a firm trial date in Georgia? I mean, there's a lot going on there. It's a multi-defendant case. Lots of things could happen. But the Georgia case is the one that I think many people are looking at. It's the one where Donald Trump, if he is reelected president, will not have an opportunity to pardon himself. What's the likelihood that we are going to get a firm date, and when might that be?
I'm really concerned after today's hearing that this might get pushed past the November election. And the reason why I say that is the judge didn't seem confident that August could actually happen as a date. And now we're, as you know, by the time we're in August, we're going to have a Republican candidate who is the nominee. And if that is Donald Trump, I could very well see somehow the judge being convinced that it would make sense to postpone this case. So, I'm greatly concerned. The name of the game has always been delay. I enjoy, like everyone else, reading the legal details, really nerding out on the arguments here. But the more complex the arguments are, the more complex the discovery is, it just delays things. So I'm not sure when we're going to get a date, but I don't think we're going to get a firm date maybe until February at the earliest. And that date will probably be after August.